Good afternoon, and welcome to the Institute for the Fiduciary Standards' fourth event of Fiduciary September, titled Reconciling Fiduciary Duty and Social Conscience. My name is Darren Fogarty, and I am the research analyst at the Institute. Today's event will focus on Robert Sitkoff's landmark 2020 paper as the SEC considers mandatory ESG disclosure. Following a presentation by the panelists, Skip Schweiss will moderate a discussion between Robert, Ron Rhoades, and Chris Fidler. Robert Sitkoff is the Austin Wakeman Scott Professor of Law and the John L. Gray Professor of Law at Harvard Law School, and is an expert in wills, trusts, estates, and fiduciary administration. He was the youngest professor with tenure to receive a chair in the history of the school, and is the only current member of the faculty to hold two chairs within the law school. Sitkoff previously taught at New York University School of Law and at Northwestern University School of Law. Ron Rhoades is the director of the Western Kentucky University Financial Planning Program and an associate professor of finance. Rhoades has over 30 years of experience as an attorney and over 15 years as a personal financial advisor. Over the past decade, no single person has written more on the importance of the fiduciary standard and investment advice than Professor Rhoades. Currently, he is a financial advisor at ARGI Investment Services LLC as well. Chris Fidler is a senior director in the Global Industry Standards team at CFA Institute. Mr. Fidler leads the promotion of CFA Institute industry codes and standards globally and helps to identify areas where new standards are needed. Prior to joining CFA Institute, Fidler was a management consultant at Thought Logic Consulting LLC and served in a number of management roles at Capital One Financial Corporation. Skip Schweiss is the president of the Financial Planning Association and CEO of Sierra Investment Management. Prior to this, he was the president of the TD Ameritrade Trust Company and the managing director of advisor advocacy and industry affairs. Schweiss is a prominent voice in the financial services industry, identifying key issues of importance to advisors and their clients. Furthermore, he is widely recognized as a leading advocate supporting the fiduciary standard and the RIA model. Today, we'll have time for Robert, Ron, and Chris to present, and we'll also have time for a moderated Q&A session. Please submit your questions to the chat, and if possible, we would like to let audience members ask the panelists their questions directly, but still ask that you submit those questions first through the chat feature. There will be a recording of this event on the Institute's website shortly after it concludes. And so with all that out of the way, I'd like to pass it over to Skip Schweiss to begin today's session.
Darren, thank you very much for introducing the session and our esteemed speakers. I'm honored to be here as moderator. Rob, I read your paper leading up to this and loved it. I thought it was one of the more analytical assessments of this whole issue that I've seen in recent years. So over to you to tell us more about it.
Oh, thanks. That's very kind. I was wondering who that other reader beside my dad was. So thank you for having me. It's very kind words about the paper, and I'm delighted to talk about this. Maybe the way to get into the topic of ESG investing by fiduciary, reconciling fiduciary duty and ESG investing, is to take a step back and identify the key policy questions, the key regulatory policy questions that arise in the ESG investing space. I want to suggest there are four frames, and the paper is about one of them, and then I'll focus on that one. So one question that we might talk about in light of the rise of ESG is corporate governance, and this would be largely then a Delaware corporate law question. To what extent should ESG be considered by corporate managers? There's a debate about maximizing returns and welfare, and what is the function of the corporation at a state corporate law level? Where does ESG play in? So that's one question. It's not one that we talk about in the paper. A second question is a matter of securities regulation, and that's a question of to what extent should ESG fall within mandatory disclosure for those issuing securities in public markets. Now that's an SEC regulatory question under the Securities and the Exchange Act. And this is a question of the extent to which you think ESG factors are material or to otherwise relevant for investors. It's about market integrity, and so it's an SEC question. The SEC is actively discussing right now what it should do about ESG in disclosure. All right, third regulatory question is investment company. To what extent should a mutual fund disclose use of ESG factors in its investing or engagement activities so that investors in the fund know what they're buying? So that when my father-in-law picks XYZ ESG fund, he understands why and how they're using ESG factors. All right, the fourth of these four regulatory questions is fiduciary. To what extent should or may a trustee or other fiduciary consider ESG factors in investing or engagement activities? So why am I starting with these four questions? For a couple of reasons. One is that obviously overlap. If ESG factors are relevant or otherwise of import for trustees, then the extent to which they're disclosed as a matter of securities regulation or investment company regulation matters. There's a difference between filed and furnished information. Likewise, if mutual funds need to disclose what kind of ESG factors they're using, that's easier or not based on securities regulation. But more importantly, there's an ongoing active regulatory policy debate. The SEC is currently actively discussing ESG factors. The Department of Labor has issued a rule that's known as the ESG rule, though it doesn't actually say ES or G in the rule. And in thinking about this, the DOL is addressing the fiduciary question. The SEC is addressing the securities regulation, investment company regulation questions. They're not exactly the same questions, and they're different policies, and it's helpful to keep these straight. So what's our paper about? What's this project? This project is about that fourth question, fiduciary investors. To what extent should or may a trustee consider ESG factors in investing or engagement activities? And to expand on that, what our paper is about is to assess the law and economics of ESG investing by a trustee of a pension, a charity, or personal trust, these heartland trust fiduciary law areas. The context are trillions of dollars are held in pension, charity, and personal trusts. ESG is on the rise. The PRI, associated with the United Nations, urges that it's mandatory. The DOL has put out a rule, another one is coming. The SEC is looking at this. So what do we mean? Maybe we should start with what do we mean by ESG and then get into what the analysis in the paper is. So by ESG, I'm using the term ESG as an umbrella for any investment strategy that could be picking or engagement, securities picking or engagement with managers that emphasizes E, S, or G factors, environmental, social, or governance factors in the impacts or practices of the companies. This is against a backdrop of an evolution from SRI, socially responsible investment, to ESG. And a kind of thumbnail sketch there is that over time, in particular around divestment from South Africa during the apartheid regime, there was this sense of socially responsible investing, that investment should consider these third-party benefits. Over time, SRI was rebranded as ESG, with bringing in G and governance factors, along with a new claim. And the claim wasn't just that it was ethical or moral to consider these factors for benefits to others, but rather you could make money. In other words, that use of ESG factors was risk-adjusted return sensible, that this was a sound investment strategy as an investment strategy, not just morally or ethically superior. Some of that rebranding reflects an effort to deal with the duty of loyalty, that in trust law, the duty of loyalty prohibits you from considering third-party effects. You can only consider the benefits to your beneficiaries. And so talking about the benefits of the beneficiaries in terms of returns makes this potentially more palatable. We'll come back to that in a minute. Okay, before we get going then in the contributions of the paper, let me do one other introductory point, and that is about the difficulty in coming to agreement about what ESG means and the directions that these factors point. There's broad consensus at an abstract level what I mean by when I say ESG, environmental, social, and governance. So there's a broad consensus that say classified boards would be a G factor, right? But what there's not a consensus about is how much weight to give each one of these factors and which way considerations under any given factor points. So nuclear energy, I can tell a story that nuclear energy is E friendly because it doesn't have carbon emissions. You can also tell a story that nuclear energy is E negative because of the risk of a meltdown. Classified boards, well, the evidence is that for some companies, classified board could be a positive, but for many companies, it's a negative. Whether I avoid nuclear companies or I avoid classified board companies or I pursue them, I could responsibly and honestly claim that I'm an ESG investor. I'll do one more piece of that. Suppose you've got a firm that is positive on classified board and negative on nuclear power, whichever direction you think is positive or negative. How do you do that? So why am I saying this? Well, because there's subjectivity. My favorite example of this is Tesla. which one rating company has as the best car company, and another rating company has worse than Exxon. That's the worst company. Well, what about Tesla? The products maybe are environmentally friendly, but the stuff that goes into the batteries are terrible, and it has, let's say, idiosyncratic corporate governance. So what I'm getting at is the subjectivity and the necessity of subjectivity in an active investment space of weighing and balancing these factors. And this will be relevant when we come to the evidence for ESG investing. I don't know how you can talk about evidence of ESG investing globally without understanding that there's subjectivity in which way ESG points. Okay, so what does the paper do, being mindful of the time constraints? We make 4 contributions. The first is taxonomies, vocabulary. We take ESG and we break it into 2 buckets. The first bucket we call collateral benefits ESG. That's ESG factors used to achieve a collateral benefit to a third party. That's old school SRI. If I were king of the world, I would just deem that that's SRI. That's what socially responsible investment is. So we have a clear set of vocabulary. The example might be, I'm going to divest from fossil fuel companies because I think that's going to be good for the environment. Right? That's a collateral benefit. That's collateral. That's not going to be, that's my investment returns. That's the benefit of the improved environment. Risk return ESG is our other bucket. Risk return ESG. That's use of ESG factors to improve risk adjusted return. What does that look like? Well, I might do active investing. I might think that E and S and G in a Fama French asset pricing model kind of a sense are useful factors that might help me identify asset mispricing in the market. And by use of these factors, if I can identify asset mispricing, I can make money. That's the theory. The story there might be, I believe I'm going to divest from this company because the market does not accurately price the regulatory risk associated with it or something like that. The other version would be active shareholding. I'm going to engage with management. That E and S and G factors are useful factors that I can use to engage with management and cause management to improve firm value through embrace of these factors. That would be the theory. So risk return ESG, that's a kind of active investment story, whether it's through picking or engagement, but that I think these factors will help me make money. Versus collateral benefits ESG, I'm doing this because I want to have a third party benefit. That's the first contribution, that taxonomy. The second is to explore the fiduciary duty of loyalty under trust law, both all 3 in ERISA, trust, and charity, and to talk about whether and to the extent to which risk return ESG and collateral benefits ESG could be loyal or not, whether or not collateral benefits or risk return ESG can satisfy the duty of loyalty. So here's our answer. Under ERISA, Employee Retirement Income Security Act, so I'm talking about pensions now, no collateral benefits ESG, full stop. What does the statute say? The statute says you must act solely in the interest of the plan participants. And the Supreme Court, in a case called Dudenhofer, has interpreted this language to speak to financial benefits, the financial returns to retirement savers. So what does that mean? That means I can use E and S and G factors as financial factors, as economic factors, as financial pecuniary factors towards asset pricing, engaging with management. But what I can't do is use E, S, and G because I think that's going to have some third-party benefit that's not part of my improved risk return. Here's a heuristic to see why this has to be right. Suppose the plan fiduciary spent plan money on that collateral benefit. That would obviously be a duty of loyalty violation. That would be spending the funds not for the plan participants. What I'm getting at is the investment function and the distribution function are on some level substitutes. Okay, so we could talk about the public policy of this. It's kind of a paternalistic notion that you shouldn't be allowed to consume your retirement savings until you are retired, and that your 35-year-old self can't decide what your 75-year-old self does with the money, and we can have a fun discussion about that normatively, but positively, that's what the law is. How does that apply to menu construction? The same way. When I build out my menu of 10 offerings and a defined contribution, 401k or 403b, I can look to E, S, and G, but they've got to be pecuniary. They got to be financial factors. How about trust law? Well, in trust law, the sole interest rule, solely in the interest of the beneficiaries, is a default rule. What does that mean? It means it was not mandatory, so the settlor could opt out and have a fairness test, or maybe could even say, I want you to invest with these social benefits in mind. The hard question there is, at what point is it no longer a trust for the beneficiaries and instead is a non-charitable purpose trust for that social objective? A useful analogy for the trust law nerds on the Zoom today would be diversification. Suppose I write a trust that says the trustee should never diversify. Well, if that's the family vacation home, maybe that's okay. But if it's a portfolio of thickly traded stocks and bonds, that's a little bit crazy. And there's an uncertainty in the law at just how far a donor ought to be able to go in prescribing these rules. What about a beneficiary authorization, right? Beneficiary gives you a release to do ESG investing of a collateral benefits type. Well, that's fine, but here's my answer. That's fine, but one, that only protects you against that beneficiary. If that beneficiary's got minor children, I'm worried about when they grow up, them suing me. And two, for how long? Yeah, okay, I gave you that waiver, but that was, then this market thing happened. Then you need to change. That's a standard waiver problem that corporate trustees are familiar with. Okay, how about charity? Charity is interesting in two ways. One is if it's a charitable trust, you must have a sole interest rule, but it's a sole interest of the charitable purpose. Suppose I'm the Sierra Club. Can I divest from fossil fuels? Of course I can. Why? Because my purpose is environmental. And if I choose to pursue that purpose through my investment program as opposed to distributions, those are substitutes. I'm not being disloyal to my purpose in allowing the purpose to drive my investment. People call that program-related or mission-related investing. The other way that's different is a lot of charities are corporations, and corporations have a best interest loyalty test, not a sole interest. So if you are, say, the Harvard Corporation and you announce you're going to divest because that's what's good for the earth, whether or not that's actually good for the earth is an interesting question, whether that would have that effect. That's a question of elasticity and whatever, we can get into that. Let's say that's what you want to say. Well, Harvard's got this educational mission, but it's a best interest test. There's more freedom, there's a little more leeway in what they do. Okay, contribution 3, staying mindful of time, is prudence, the duty of prudence, and a sober look at the literature of financial economics. So the duty of prudence in the investment space is the prudent investor rule. It's got a market risk and an idiosyncratic risk dimension. The market risk dimension is you have to invest for risk and return objectives reasonably suited to the purpose of the account. And idiosyncratic risk rule, you need to diversify, and this is a really good reason not to. These market and idiosyncratic risk rules are supported by process values, record keeping, ongoing monitoring, cost sensitivity. Here's the difference between trust and antitrust. In antitrust, never write anything down. In trust, write everything down. Right? Okay, right. Process values, ongoing monitoring, cost sensitivity. Active investing is fine. It just needs to be a reasonable, documented, and periodically revisited analysis. So how does that play out for ESG investing? What we want to suggest is that there are really two different questions, and a lot of literature has conflated them. One question is, do E and S and G factors have a relationship to firm value? There's no relationship to firm value. It's hard to see how they're relevant to investment. But if there is a relationship to firm value, then comes question 2. Can I exploit that relationship for profit? A lot of the ESG literature looks to studies that finds that the answer to question 1 is yes, there's a relationship between ESG and firm value, and assumes that means you can exploit that relationship for profit, which is hard to do in public markets. So what's the theory and what's the evidence? The theory and the evidence on firm value for G is straightforward. There's an obvious theory for G having an effect on firm value. What's the evidence for that I can make money on it? That's a little bit more mixed, but it's a traditional factor. What about E and S? The theory there is that these are proxies for risk and proxies for management quality. If would that I could perfectly evaluate managerial quality, right? Then I go build my own hedge fund. We'd be good to go, right? Maybe these are a proxy for management quality. Well, are these factors exploitable? And let me say there is some evidence, mixed, but there's some evidence that there may be a relationship to firm value on these. Are they exploitable? Well, for active investing, you need to tell a story about, beating the market, and that's really a story of I'm not in an efficient market. Maybe I'm in fixed income, or I'm in China, or I think that I've got systematic market mispricing that I can exploit with my Fama French ESG model, and all the usual caveats, but active investment strategies apply: diversification, risk adjustment, transaction costs. Or it could be engagement. You know, I'm going to engage with management. You know, management, if you have better S, you're going to have better outcomes and you're going to be a more valuable company, and the value of my shares will go up. That's got a collective action, a free rider difficulty, but there's some evidence that this can work, that you know, hedge funds and others might be able to have returns based on this engagement. What's the role of the law here? It's reasonableness in the process. You don't want the judge telling doctors how to take the appendix out. You want them to say, did you do this, you know, the way reasonably in light of the industry? Same question here. Okay, fourth and final, and then I know I'm out of time. The last thing we address is a permissive versus mandatory. There's a lot out there that ESG is not just permitted for a fiduciary, but that it's mandatory. Fiduciaries must do it. I want to say that's wrong in law, that's wrong in policy. It's wrong in law. The prudent investor rule says any type or kind of investment. It's agnostic about your investment strategy. So another way to say that is if my Aunt Ruthie is the trustee of a trust with $100,000 in it, and she puts that trust, the equity portion of that trust, in a Vanguard total market index that doesn't have an ESG component, she's not in breach of trust. She's not in breach of trust. On the other hand, if she used ESG factors in a documented way, she's not in breach of trust. If she decided ESG factors are great, but they're overvalued because everyone's running to ESG, so I'm going to short all that stuff, I'm going to go all in on sin or whatever, she got a documented analysis, that's okay too, right? We are agnostic on type or kind on strategy. As a matter of policy, the ESG rubric is too fluid and subjective. What kind of a mandate is it? If both classified boards and no classified boards could satisfy the mandate. All nuclear power, no nuclear power. Tesla or Exxon or neither. It's a meaningless kind of a mandate. And also passive and contrarian investment must be legal. Cannot be per se illegal. I think the contrary confusion comes from the findings that there's a relationship between these factors and firm value. All right, last thing I want to say, if I had to give you a punchline summary, one takeaway, if there's anything you're going to remember from this, from my droning on and on and on, let it be this. There is theory and evidence that ESG, risk-return ESG investing can be a real thing. Now, what does that mean for fiduciaries? The law neither favors nor disfavors ESG or any other type or kind of investment strategy. It's the same prudence and loyalty test. Are you loyal? And have you got process values backing up your prudence for whatever the strategy is? It's not like the statute says, these are the investment rules. Provided, however, if it's ESG, these are totally different other rules. It's just one set of rules that applies. It's plausible that ESG could satisfy those rules. It's plausible ESG might not satisfy those rules, just like any other type or kind of investment strategy. Okay, thank you much. Happy to continue this conversation.
As a fiduciary nerd, that was a pretty fun 20 minutes. Thank you, Rob, for walking us through your paper and a summary of it. Now I want to hear what my longtime friend, Mr. Rhoades, has to say.
Great. Well, thank you. Let me get the right screen here going.
Looks like you have the right one.
Okay, great. Okay. Well, I was so highly impressed with the analysis of Robert Sitkoff's paper last year, and I was pleased to hear him at the Heckler Institute presentation as well. I kind of wondered, in terms of this presentation, how do you apply the factors? There's a lot of different ways of doing investment analysis. But one way would be to look at macroeconomic factors or trends and then try to apply them. But then you need to go beyond to an individual security analysis and look at valuations and a whole bunch of other things. But I'm going to focus a little bit today on basically just the economic trends part of this. All right. Of course, a disclaimer, these are my views and not of anybody that I'm associated with or whom I may have been kicked out of their organization previously. So the paper basically said a trustee can undertake a program of ESG investing if it's documented, reasonable analysis, and there are some expected return benefits that are offset any cost involved in basically doing that. So kind of the question is there support in financial analysis for any of these factors as we apply them to particular industries. So I'm going to go pretty fast through these slides. Basically, let's look at oil and natural gas. Well, we have a report out this year that basically predicts that oil demand will peak in 2029, natural gas in 2037. But one of the questions is, well, before then, will there be a lack of investment? Will we in fact see oil prices increase? Even some predictions this year that we'll see $100 a barrel oil because of the lack of turning on the spigot, so to speak. BP actually issued a report last year that basically said oil demand has already peaked. I don't think that's the majority view by any view. And this is a slide out of their booklet that basically shows that depending on different scenarios, including a rapid decline, which is fairly well expected because of regulation, you're going to see a dramatic decrease in the consumption of oil, especially starting around mid-2024, 2025 or so.
Hey, Ron?
Yes.
Sorry to interrupt you for a moment. I'm only looking at your title slide. Is that just me or others?
The slides are not coming up, Ron.
Okay, well, we'll try to switch the slides again.
Yeah, we see the first one, but they're not moving with you. So
I don't know if Darren can assist with that. Now we're moving.
there we go. Yep.
So you got the outlook for oil demand slide?
Yes.
Okay, great. So just to go back there a little bit, let's move on to coal real quick. I'll try to keep within my time frame here. We got 5 minutes left. Surprisingly, coal has increased in terms of its consumption. A lot of that is due to basically consumption in China and some of the other Asian countries going up. It's decreased here in the United States. We've seen a lot of coal companies actually file bankruptcy as a result of that. So that's a mixed bag. It might depend upon the producer there, and certainly it might depend a great deal on what China does in terms of whether it's going to not build as many coal plants as it plans to, or even shut down some. We also have to face litigation risk in this area. Against the oil companies, U.S. lawsuits have pretty much failed, but in Europe, courts are ordering some of the major oil companies to cut production. And potential monetary damages there, none of the lawsuits have succeeded in that regard, but I wouldn't be surprised in Europe, especially if we see something like that. So just looking at our carbon producers, one of the big macroeconomic trends is that solar costs are continue to come down, battery costs continue to come down, which are basically making coal and oil basically not the lowest cost source of some types of energy. Energy prices in the meantime will be very volatile. So long-term investors might justify the exclusion. You need to kind of do a discounted value approach in terms of looking at your return over a long period of time. But I would also say there's another factor that comes into play, and that's carbon capture. If they ever get low-cost carbon capture, that could change the whole scenario here dramatically. Gambling is a mixed bag. Land-based casinos are basically not doing really well. Online gambling, however, is exploding. And some land-based casinos have basically developed a significant presence in online gambling, for example, MGM. So the full avoidance of the gaming industry might be very problematic from a macroeconomic perspective. You'd have to really analyze what individual companies are doing and their trends in terms of attendance, and that's kind of difficult given COVID. Firearms, huge industry, projected at a pretty good growth rate here in the United States, 6.4%. However, there's a potential liability risk. In fact, in July, Smith & Wesson, basically a lawsuit against them was denied and a motion to dismiss. And the Sandy Hook case is going to trial probably early 2022. And another judge ruled in April 2020 that the federal law doesn't prohibit the claim of a family of a mass shooting victim, the one in Las Vegas, to pursue that. So we have potential litigation against gun manufacturers that might significantly impact their profitability and even their ability to stay as entities going forward. We also note that Mexico just recently sued gun manufacturers for basically flooding the market in Mexico with U.S.-made guns. We'll see how that goes. That's a more of a long shot. So the conclusion here is there's a lot of risk there in terms of the future profitability of the industry, but again, you need to look at this really by company by company. Tobacco, very low growth rate expected worldwide, only 1.8%, and there's a lot of litigation risk here. Just recently, it's a $43 million verdict against Philip Morris, and just a huge amount of cases that are going forward here that are not blocked by the state settlements that were done. So huge litigation risk, small growth rate, fairly easy to say, hey, from a macroeconomic standpoint, we can perhaps do this. A couple comments. There's lots of ESG ratings, as Robert Sitkoff's paper points out. I have not reviewed them in detail. It's kind of hard to figure out, hey, is this ESG rating, what does that mean from the standpoint of future returns? How are they actually doing it? And I would also comment that this is just the first step in the analysis, and certainly you wouldn't reach these conclusions based on this slide presentation. Anything you do from a macroeconomic standpoint, you really need to do a detailed analysis and then look at beyond that on an individual security basis. For example, Shell, for example, big oil company, you might say, I want to exclude them, but what else is Shell doing in terms of its business operations? Right? So you also have to update your reviews periodically. And I just want to comment, there's not only some quotes out of the paper here on active investment strategies, basically, do they offset the additional risk? But also a recent paper that came out from the Chartered Financial Analysts, the CFA Institute, which basically supports the view that active investment is very difficult to justify, and I hope we hear from Chris on that. So thank you. All set.
Ron, thank you. You had a lot of good stuff there, and you had to kind of rush through it. So I hope we can come back to some of that in the Q&A and address your comments and those of Robert's. Chris, thank you for being here and for on somewhat short notice being here, and looking forward to hearing your remarks. So go ahead.
Yeah, well, first, I want to say thanks to the Institute for the Fiduciary Standard for having us, and thank you, Skip, for moderating the panel. And to you, Rob, my compliments on a really excellent paper. I'm not a lawyer, and even I could understand it, so I think that's a high praise right there. So I'd like to share my reactions and some observations around some of the main points of the paper. The first one is that the paper rejects the growing claim that risk return ESG is or ought to be mandatory for a trustee. And CFA Institute has put out a very similar position. We have a position statement on ESG integration, which is, that's our term that we use for what Rob's paper calls risk return ESG. And it says that integration of ESG factors is not a violation or obligation of the CFA Institute duty of care standards, which are loosely analogous to fiduciary duty. Integrating ESG factors into the investment analysis process is left to the professional judgment of the investment professional and as directed by the client. And such integration is consistent with a manager's professional duty to consider all relevant material information in the investment analysis and decision-making process. The paper goes on to say that material ESG factors are an important component of a complete and thorough financial analysis for any actively managed investment portfolio. And we encourage all investment professionals to consider material ESG factors where relevant as an important part of the analytical and investment decision-making process, regardless of investment style, asset class, or investment approach. So those are our top-line views, our top-line views on ESG integration. And to support investment professionals and give them the tools for how to do this, CFA Institute, over the past couple of years, has developed a certificate in ESG investing and has added a significant amount of ESG-related material to the CFA program curriculum. The second point from Rob's paper that I'd like to address is the assessment of the current theory and the empirical evidence for whether ESG investing can provide superior risk-adjusted returns. And here I just want to offer a little bit of maybe a caution or a little bit of an expanded view. And Rob is correct that there's been thousands of empirical studies that seek to determine the causation or the correlation, if you will, between ESG factors and investment returns. And overall, the conclusions are mixed. So you could draw, whatever conclusions you like from that. You could, I guess, cherry pick which studies you like better to, support your views. But I would caution that all of these studies, to a large degree, maybe oversimplify ESG issues because they necessarily boil them down into quantitative factors that can be used in quantitative regression analysis. And to be clear, there's certainly merit in that sort of investigation, and I think more should be done. It's an area that needs further investigation. But what these studies, I think, don't reflect is the value that ESG information can have as a tool to enhance the quality and depth of fundamental investment analysis, particularly if your investment horizon is over a very long period of decades, and particularly if you believe that ESG factors or issues will have a greater impact in the next 50 years than, say, in the last 50 years. So to trustees that look at this data and say, gosh, I don't know what to do with all these studies, mixed results, I would just caution to not throw out the baby with the bathwater. If you do have a long-term investing horizon and you have beneficiaries that will be receiving benefits many decades out in the future, it seems prudent to at least consider maybe how these exogenous factors may influence your portfolio over the next decades, and consider what options you might have to protect the value of the portfolio. And active investing is not the only way to do that. There's many other ways that one might protect the portfolio against these exogenous factors. And the last thing I wanted to comment on is the paper's disentangling of risk-return ESG from collateral benefits ESG, which I completely agree with the distinction. I think it's really brilliant that it's based on the trustees' motivation around sole benefit for making this distinction. And I just think it's so clear how trustees need to think about this under US law. And I think Rob's paper should just put this whole issue to bed. It doesn't need further debate. But alas, I think even armed with this knowledge, poor trustees now many of them have to go out into the marketplace and find products that align with these motivations. And that's not so easy. It's not like they're clearly labeled or categorized as risk ESG and collateral benefits ESG. And of course, the decision is very important to trustees because you're on the hook here, and you could be legally liable if you make the wrong sort of decision. And it's a huge problem. And this is in part what inspired CFA Institute to undertake the development of a voluntary global industry standard that would provide investors with the information that they need to make this determination. And the standards that we've developed are called the Global ESG Disclosure Standards for Investment Products. They've been 2 years in the making, and we are weeks away from releasing them. We will be putting them out on the 1st of November. And I would just encourage trustees or asset owners who are subject to fiduciary duty to start requesting from investment managers an ESG disclosure statement that complies with the global ESG disclosure standards for investment products. because this will give you the information that you need to make this determination, whether a product follows a risk return ESG approach or whether it follows a collateral benefits ESG approach. And it will provide you some documentation to substantiate that you've done your due diligence and you've looked at and you've made that assessment for the product that you're investing in. These standards are free for use for all managers and other stakeholders and users. And this is just one of the things that we do as CFA Institute as part of our not-for-profit mission to help protect investors. So with that, I'll wrap it up and pass it back to you, Kip.
Yeah, thank you, Chris. And thanks for the great work CFA Institute does. I look forward to seeing those standards published soon. I share your wish that Rob's paper might put this issue to rest, but I fear in reality that may not be the case. I've watched this issue ping pong back and forth across the last 3 presidential administrations with some executive orders, and I'm sure we haven't heard the last. So Darren, how do we handle Q&A coming in? I cannot see any of that.
Yeah, we don't have any questions currently, although I encourage the audience members to submit any questions if you do have any. And in the meantime, perhaps some of the panelists can react to some of the things the others have put on the table, and Skip can sort of. Yeah,
I've got a couple of questions. I want to start with Chris. You just got close to this issue, and I wanted to ask you about it. It seems like there's a term out there now called greenwashing, where certain products or services or companies are, paint themselves green, and are they really? And what is CFA Institute's thinking around that topic, and how we can get at the real status of an ESG investment?
Yeah, great question. So to put sort of a more formal definition on greenwashing, we would call it any sort of communication or marketing about the product that would create a misunderstanding or a misrepresentation about the way ESG issues are considered in a product's objectives or in its investment process or in stewardship activities. And because of the zeitgeist right now and the interest and enthusiasm that in the marketplace for these kinds of products, there's a lot of pressure, I'd say, on managers to say that they've done this. And therefore, I think that can lead to some temptation about maybe overclaiming. So CFA Institute has always been of the opinion that disclosures need to be fair and full and representative of the product, and you can't make claims that you can't substantiate. So the standards that we're developing really go into more detail. They seek to identify exactly the type of information that needs to be disclosed, and how to do that in a fair and a full way, so that investors can understand and compare products on equal footing. So while it doesn't, it's not a standard for sustainability. You can't use it to say this product is is ESG. This one's not. This one's sustainable. This is not. This is responsible. This is not. We're not getting into that sort of naming and labeling requirements. It's simply a disclosure standard so that investors can get the information that they need to determine whether or not the product meets their own ESG related needs and preferences.
I like that approach, and I'm reminded of Rob's comment, I think fairly early in his presentation, about one person could categorize nuclear as, I'll just use the word bad. Others might categorize nuclear as good because it doesn't emit anything but steam until something goes wrong, I guess.
And I'll add, there's another layer to that. So you might judge nuclear good, no carbon, nuclear bad because of water or meltdown risk. But then we might have differing views of how the market has priced that. We might think that the market is overvaluing or undervaluing. So I could, with a straight face and good faith, claim to be an ESG investor and both pursue and avoid nuclear power on any of those various theories as they overlap. And this is part of, I think, the nonsense of saying that ESG must be, because I don't know what that means given the fluidity of the rubric and the subjectivity inherent to the analysis. And that's not a knock on ESG. That's what active investment is. It requires a subjective judgment on which criteria matter and in what directions they point and how much weight to give the different factors.
Thank you. Darren, I've got more questions, so just signal me if any questions are coming in from the audience. I'm sure I'd rather address those than my own.
I will let you know as soon as one comes in. Until then, keep going.
Thank you. So you guys are providing me great segues. So, you know, Rob, I think you gave us kind of a legal framework around how to view ESG factors in investing, particularly by fiduciaries. Ron, I thought you took a different angle on, hey, there's risks involved in some of these industries that should be considered by fiduciaries. Can you square the points you made with Rob's?
Well, I think if you're going to consider ESG factors, especially if you're a defined contribution plan sponsor selecting funds, if you're governed by ERISA generally, if you're a trustee with no instructions otherwise of a private trust, for example. If you're going to pursue active investing in any case, you need to look at expected returns, but also risk. And it's difficult, I think, in terms of doing the security analysis and applying these factors. For example, we can look at carbon-based industries. We know that there's tremendous regulatory pressure up in most parts of the world to basically decarbonize. However, is that already factored in the prices? So you have to go further. You have to look at that and say, wow, you know, maybe this particular oil company or natural gas company, what is the expected return? And then the next question you need to ask is, okay, when is the regulatory impact going to really be felt in terms of driving demand down and the like? Because you're looking at valuing a stream of cash flows, essentially. And then you've got to look at the litigation risk. And how long will litigation risk take to appear or affect the stock price? All of that analysis, I think, can be undertaken. I think the key question there is all the money spent doing that analysis, the cost of that analysis, going to provide real benefits? I think, generally speaking, we know that high-cost active management fails most of the time, on average. The question is, can you undertake ESG analysis in a low-cost way, probably using economies of scale, and then apply that to your duties of loyalty, your duty of prudence under ERISA or the like. So I think it's, and I go back to the CFA Institute paper, that I think is going to be very influential going forward in terms of litigation. It shows how difficult it is to justify active investing compared to passive investment strategies. And so if you're going to pursue the ESG route and you're governed by ERISA or trust law, the sole interest standard, you really need to go through the documentation process. And your analysis has got to be good. You don't have to necessarily be 100% right all the time, but you're really going to have to document your analysis, because chances are you will be second guessed at some point in the future.
Yeah, thank you for that. I think that last that summary at the end there, I think, aligns with some of the points Rob made. Robert, are you familiar with the current state of play with the Biden administration on where we are with the directive around ESG factor considerations for fiduciaries?
There we go, I'm unmuted now. So I think that the current regulatory activity is in my second and my fourth question. The second question is securities regulation. The SEC is looking at ESG currently, and several of the commissioners, most of the commissioners have now given speeches about their views, and that's ongoing. But you're asking about the fiduciary side, which is the DOL. And so maybe it'd be helpful to take a few minutes and talk about the DOL guidance and rulemakings against the backdrop of your earlier remark about what you call ping pong or whatever from in one administration to the next. So here's what I want to say. Setting aside the rulemaking that happened just at the end of the Trump presidency, and I'll come back to that in a moment, the department put out a series of sub-regulatory guidance, which is lawyer talk for not a formal rulemaking, just a statement of we are the Department of Labor and here's our view. And it put out a series of these under 3 different administrations, for which the media and the kind of received wisdom that these were very different expressions of legality for ESG investing from one administration to the next. And that's not actually true. The operative language in all of the guidance documents more or less prescribes the same principle, which is that ESG, also ABC and XYZ, are fine as economic factors within loyalty and prudence and not as anything else. What's different from one guidance to the next document to the next is the tone and the posture and the attitude and the kind of atmospherics around the unchanging, actionable, operative words. So what I mean by tone, it's very different when you read guidance that says, and you need a documented analysis versus, and you need a documented analysis because it seems unlikely that this could be true. So like there's a tonal difference between them, and that's what's being picked up on in the media. But the actual rule has been the guidance has been quite consistent. Okay, so now we fast forward to the end of the Trump administration. Towards the end of the administration, the Labor Department put out a notice of a rulemaking, what came colloquially to be known as the ESG rule. That proposal was onerous and very much discriminatory against ESG investing factors. It read as if there was a presumption that E and S and G factors are being used for collateral benefits and disloyally, and you had to get out of that. It didn't actually say that, but that's kind of the attitudinal posture of that proposal. And it got a lot of criticism, including my co-author and I, Schatzenbach. We filed a critical commentary letter, more or less saying what we say in the article, same rules. What you should just do is say, these are the rules, and they apply to ABC, ESG, and X, Y, and Z. So then the final rule came out, and my favorite anecdote about the final rule is within 30 minutes of the final rule coming out, USSIF put out a press release how outrageous it was, which, you know, there's a lot of scholarly study of the rule before that press release happened. The final rule was reported as the final anti-ESG rule. The final rule is neither anti nor ESG. The actual final rule just says you have to have a duty of loyalty and duty of prudence, and that means pecuniary factors only. It's basically the whole rule. I mean, you know, and in fact, you know, there's some nuances and there are subtleties about qualified default investment, QDIA, and we can go ERISA nerd on that and whatever. But the main point is that the heart of the rule is pecuniary factors are okay. The problem is that against the backdrop of the original draft that singled out ESG for heightened review and extra considerations, people read the final rule as pecuniary factors only and ESG are not pecuniary factors. But it doesn't say that. It just says pecuniary factors are those that bear on risk and return. Now, ESG factor could bear on risk and return if that's how you use it, but it could also have nothing to do with risk and return if that's how you use it. In hindsight, maybe it would have been better if the final rule had another section, you know, risk and return factors may, but need not, or not necessarily include : ES and G, right? Okay. The Biden administration, the Labor Department has announced a moratorium on its enforcement of that rule. That's not a get out of jail free card. One, because private plaintiffs can still enforce the rule. The rule is law. And two, the rule is not that different than the background statutory principles and common law principles of loyalty and prudence. What is the DOL going to do? Well, the DOL has a draft revision to that rule. It is, it's been sent to the OMB, the Office of Management and Budget. It which means it's being under review, and then it'll go back to the department and be promulgated. So that means sooner than later, by which I think we're going to measure this in weeks and months, not years. This is coming sooner than later. What will it say? That's hard to predict. I think that if what it does is cleans up pecuniary factors so that it could to put to rest market concern that might not include ESG, that would be, I think, a benefit. If it were to go further and say collateral benefits, then I think the rule is going to be subject to challenge as inconsistent with controlling Supreme Court precedent. And so, interesting times.
Yeah, I appreciate all of that. I was often asked by media and others as some of these new administrations came in and issued executive orders and rules and then non-enforcements and so on. It seemed like it was making headlines, and my comment was, I don't think there's really much difference between. I don't think we're making huge changes here, but that didn't play well in the headlines. We are coming up on our time. Chris, what are fiduciaries doing today, let's say plan committees doing today in this arena? I read a lot about their, what are the guidelines? What are we supposed to do on the ground? How are we supposed to handle this? What are you seeing, hearing, or what should they be doing?
I actually can't speak to that too much. I have some experience in that arena, but I don't think I have enough experience to say what's typically going on in the ground and where trustees' heads might be on this issue. I think, though, what I hear generally is caution. It seems to be unsettled, and so there's, I think, definitely some reluctance to go down the path of active management and trying to justify it. Seems like the more cautious thing is just to steer clear.
Is there, so we have 3 minutes left. I'm going to ask for a 1 minute or less answer from each of you on my closing question. I've sat on plan committees myself, and we try to pick the best funds in each of a bunch of asset classes and target date funds and so on. What would be wrong with doing that and then putting alongside that menu some sort of ESG or maybe 2 or 3 ESG type funds? Because the debate seems to be, well, you might not want to do that to just replace a large cap growth fund, but what if you put them side by side on a plan menu? I'll just go left to right across my screen. Ron.
I think ERISA requires every choice that you put in your investment menu to meet the duty of prudence, the duty of loyalty. So like putting up there, well, here's an ESG fund for those who like it. You might get lesser returns. That's not going to satisfy the standard.
Thank you. Chris, your view?
Agree. I think only risk return ESG funds are allowed to be put in. And if you do put them in, I think then you could run into problems with your plan participants really understanding what the differences are between these funds. So then you have the need of this problem of trying to understand the difference of funds, then gets translated from the trustees making the menu plan decisions, then down to the investors who might even have less investment knowledge and be less familiar with funds, and you get into the problem of education. So I think there's some risk in doing it, even though a lot of plan participants might really want that option. Collateral benefits, they might want the option. It's just not really, I don't think, a possibility right now under the law.
Thanks. Rob, last word.
So I agree with Ron and Chris and in their description of the where the law is, and I'm just going to suggest that here's the public policy that underpins it, and it's contestable, but this is what the policy is, and that is that we give you irresistible tax incentives to save in these retirement accounts. We do that to induce your younger self to lock money up in a fiduciary solution subject to fiduciary safeguards, so that it grows for when you retire and your retired self makes those choices. And as much as your 35, 45, 55-year-old self might like to spend your money on an environmental or social objective, It is your 60, 70, 80-year-old self that gets to make the withdrawal and then spend it on those objectives. And the purpose of the tax subsidy is to ensure that the older retired version of you gets to make that choice. In the meantime, it's fiduciary principles that protect that fund.
Right on schedule. I appreciate the varied insights each of you brought to this discussion. I applaud the Institute for putting together another great Fiduciary September, including this panel, and so brilliantly selecting panelists. Darren, thanks for your skill in navigating us through this. Any closing comments from you? Logistics or anything?
It's all been really interesting for me because I studied the environment in my master's degree. So it's this whole ESG conversation has been very interesting and cool to hear different perspectives, especially about some of the environmental stuff. So yeah, thank you all for coming. Appreciate it.
Thank you. Thanks to our audience for attending, and I hope you got a lot out of it as I did. Take care, all.
All right.
Thank you.